I've had a number of clients come to talk to me of late. These are non-US citizen clients who want to travel abroad but are afraid to do so because they have heard the stories, and the stories are, in most cases, true, about people being detained at the airport or turned away at the airport. While this has always been a problem, it's definitely a much bigger problem now during Trump 2.0, as this has obviously become a point of emphasis with Customs and Border Protection to turn people away or issue notices to appear in the immigration court for people returning to the United States. Hello, I'm attorney Louis Haskell, and today I saw this article, let me share it here, which I want to talk about, not because of the political headline, I couldn't care less about that, but because it points to what are so many problems in our immigration system, all of which are, of course, being kind of highlighted. The first problem that we have that this article shows is that all of this is in the discretion of Customs and Border Protection. And I think this guy may have run into what I would like to call a rogue agent. Unfortunately, he has a criminal record. I'm looking for that record, but he has a criminal record. One, I think, is driving on a suspended, something like that, which absolutely is not an exclusion ground. And the other is a marijuana possession and driving under suspended license. So the marijuana possession may or may not give rise to an exclusion ground. And I'm not sure that the Customs and Border Protection officer is in a position to figure that one out. And I'm not sure that the Customs and Border Protection officer is in a position to figure that out. And the driving under suspended license is hardly worth discussing. So again, I'm not sure that this agent was even within his rights to harass this man. However, let's say that the marijuana possession is a problem. That brings me to one of my biggest pet peeves. This is a 2004 conviction. His last conviction, which I believe was for the suspended license, was in 2007. However, in immigration law, there is no statute of limitations for these things. I had a client who, like this fellow, was coming back from Canada. He had a conviction from the 1970s. It was a serious conviction, but it was from the 1970s. My guy was 80, and sure enough, they put him in removal proceedings for an offense which, well, at that time was about 40 years old at the time that they did this. And that's absolutely allowed because, as I said before, there is no statute of limitations at all, no equitable tolling, just nothing that puts an end to that. The other problem that we have, this person's a lawful permanent resident, and most of the people coming to see me are lawful permanent residents. And what they're learning the hard way is that in immigration enforcement and removal law, there are two different types of removal. There's deportation, which is removing people who are in the country. And then there's exclusion, which is not letting people in. So anytime somebody leaves the United States and tries to return, they're subject not to deportation, but to exclusion. And even if they're paroled into the country to go to the immigration court, they're still in exclusion proceedings, not deportation proceedings. And that's an important distinction because there are lots of times when a person might not be subject to deportation. In other words, can't be deported, but could be excluded. And if you think about that, I mean, that makes sense that people who are lawfully in the United States it's a higher bar to kick them out of the country than the bar that we put in front of not letting people in the first place. So the best example of this involves crimes involving moral turpitude. That's a very broad category of crimes. It's an annoying category because it's very hard to figure out what is and is not a crime involving moral turpitude. And it really is the court's kind of deciding on a case-by-case basis because this phrase does not appear anywhere else outside of immigration law. But to deport somebody, they need two separate crimes involving moral turpitude, at least after they've been here a little while. To exclude somebody, you only need one. So you can have a person who's been living in the United States for decades, as this guy has, and say he has one crime involving moral turpitude. So he's living here fine. ICE can't touch him. They're leaving him alone. And he's not vulnerable to ICE. But the moment he goes to visit, well, in this case, Canada, the moment he goes back to his original country, or frankly, any country, I had a client once, he went to Niagara Falls, wound up in Canada. I guess it's not that well marked, and wasn't allowed to come back. He was excluded. In his case, he wasn't in lawful presence. So he had no way of coming back in. This fellow at least has a green card. But this is something that people need to be very careful about, because people who are in the United States, have a conviction, are having no problem because they're not subject to deportation, may suddenly find that they're subject to exclusion if they leave the country. And this is as true of lawful permanent residents as it is of students or tourists or any other type of non-immigrant. And that is something that is just grotesquely inappropriate, that somebody who's been in the country for decades and is not subject to deportation could suddenly find themselves getting kicked out of the country or not being let into the country because they took a trip abroad. So these are problems that people are encountering. Another issue, which isn't showing up in this fellow's case, but we're seeing quite a lot of, is we all know people who have green cards and have left the country for more than 6 months and did not have a problem. When you have a green card, the requirement is that you be in the United States more than you're somewhere else. And so leaving the country for more than 6 months in a year, so more than 6 months at a time, can be an exclusion ground. You can be deemed to abandon your residency. I'd encourage people who can wait until 2029 to travel to wait. But beyond that, I would encourage people who want to travel or need to travel or don't want to wait to consult and to look into what kind of problems they might have if they go abroad and parts that they can prepare. I mean, I had a client come in the other day. He does have a criminal charge, but not a conviction. So I think he's going to be fine, but I do want him to have with him some documentation so that if he does get pulled aside by Customs and Border Protection, he'll have the documents in hand to show him, hey, look, I know what you're talking about. I feel you. I hear your problem. I hear your concerns. Here are the documents that you need to see you must let me back in. And so it's always good to be prepared for what kind of problems you may have. But it's also good to know if there's a likelihood of a real problem. It's good to know before you go, and you may want to choose a different path. So we are here. If you need any assistance, please don't hesitate to call. Thank you.